Welcome to this presentation. That is the final presentation for this course, the final chapter in our textbook, Chapter 19. The topic here is analyzing a contracts problem, putting theory into practice. And in this module, we're going to talk about, we've kind of covered the law up until this point, but in some cases it's been a little theoretical. And so we're going to try to connect the real world, the cases that you may confront in your professional life, with the theory that we're talking about. And we're also going to pull in some topics that you may have learned in other classes. So let's begin. So this first slide really would work in virtually any legal class, because invariably the reason that we study a particular topic is to answer questions, to meet our clients' needs, to resolve problems. We have some question that we're not sure exactly what we should do or what the court's going to do. And so we need to look into it and come up with what our best guess is as to how this matter will proceed. And typically the attorney, it can be another paralegal, but somebody assigns us a problem. The attorney may want us to research the law. The attorney may want us to prepare a document. The attorney may want us to interview our client or some other witness. But at the end of the day, usually there is some question that we are resolving, or at least we're giving information to someone, or we're getting information from someone. And so a critical part of that process is knowing what the vision of the assigner is. What does the assigner hope to accomplish? What does that final product look like? And so when you're presented with an assignment, here are some things to think about. And I'm going to start by sharing with you some of my less than successful experiences in this area. One of the things that I did early on when I would go to meet with an attorney about a particular case is I would take almost no notes. The reason that I did not take notes was because I thought it would be rude to stop making eye contact, that it would be kind of disruptive of the flow of the conversation for me to start writing while he or she is speaking. And so I would just listen carefully. The other thing that I did that was equally unwise was I would not ask many questions. I would decide not to ask questions primarily because I thought that my questions would reveal my ignorance. I did not happen to go to law school in Texas, and so when I came back to practice here, some of the Texas-specific answers to questions I just didn't know, and I didn't want to appear stupid. And so I would kind of go along and kind of act like I understood, and what I would think to myself is, okay, I'm going to rush back to my office and do some research so I will be able to connect the dots. I don't really understand what he said, but once I get back to my office, I'll kind of fill in the blanks, get all the pieces to fit together, and I'll never have to reveal that I didn't really understand what this person was talking about. Those two strategies were really, really deeply stupid on my part. They caused a lot of problems, and I'm going to strongly advise that you do neither one of those approaches. And let me explain to you why. The first one, the not taking any notes, is probably the one that's most stupid, if you can rate them that way. It is very disconcerting when somebody is giving a detailed, fact-intensive assignment and the other person's not taking notes, because the person speaking is thinking, you're not going to remember all this. How could you possibly remember all this? You're going to get the facts confused. You're going to come back asking me for more facts. This is really kind of disrespectful that you aren't writing it down, because by you not writing it down, you're communicating to me that you don't think what I'm telling you is important. I didn't think that way when I was the one receiving the assignment, but as my career progressed, I became the person who was giving out the assignments. And when I would have somebody look at me and not take notes, I would think either they are so lost they don't know what to write down, or they are too cocky that they think they can remember it all, but really they can't, or they are just not being responsible. It did not at all create an impressive presentation. And that was the moment, the aha moment, when I realized, wow, all those times I didn't take notes, the attorney was thinking to himself or herself, this person is not doing a good job for me. The second part was not asking questions. Now, when you don't ask questions, the person giving you the assignment can't gauge your level of understanding of the assignment. So have you ever been in a situation, perhaps when you've been with somebody whose first language isn't English, and you're trying to explain something to him or her? You aren't quite sure how robust their understanding of English is, and so you're saying things, and the person is nodding their head and maybe even saying yes or I understand. And maybe they do understand, and maybe they don't. And it can lead to this very kind of unsettled feeling. I'm not sure. Do I keep on talking? Do I act like they understand? Or should I continue trying to explain in the hopes that I stumble across some way that will make it clear to them? Well, that's kind of the way the attorney feels when he or she is explaining a legal topic to another person. Uh, and this is especially true when the other person isn't an attorney. Many times attorneys don't really know how deep a knowledge that paralegal may have in this subject. And so the attorney, when he or she's not getting feedback clues, may either feel like, oh, okay, well, I don't have to really give any details, or wow, I can't tell if this person understands or not, so I'm going to have to overwhelm them with details. Neither approach is very helpful. And so the smart paralegal or the smart junior attorney is the one who says, I understand that part. Let me repeat it back to you to make sure. But I didn't get the second part. I got this part of the second part, but you lost me on this part. That actually communicates competence to the attorney, because the attorney now feels like, oh, I can trust this person. This person is going to tell me what makes sense to him or her and what doesn't make sense. That relieves a lot of the stress that exists, and it actually makes the exchange quicker than it otherwise would have been. Another reason that you want to level with the attorney, the assigning person, your level of understanding is that it's a lot easier in most cases for the attorney to give you that short information than for you to independently find the answer. And keep in mind, in a law firm, time is money. So if the attorney can give you a 5-minute tutorial in this area of the law, that's a good investment of time if it would have taken you 45 minutes on your own to get to that same level of mastery. Let's say you're billing at $100 an hour. Well, 5 minutes is what? 1/12 of $100. So that's, uh, less than $10. Of course, it's the attorney's time too. So it might be, $30. It might be the cost of that 5 minutes. But think about if you had to spend 45 minutes doing that. Well, now we're talking $75. So you can see time literally is money in a law firm. And when you um, uh, do something that takes more time, you are in some sense stealing from the client, because the client's ultimately going to pay for that time. And one of the things as professionals we need to think about is, how can we advance our client's interest? And even if it means maybe asking a stupid question or being a bit embarrassed, if it's going to result in our client saving money, well, then that's a pill that we need to swallow and do what we need to do. So don't hesitate asking questions. And these may be factual questions. I didn't get that step there. Could you repeat that part of the story? Maybe you were taking notes during that time, or maybe the attorney skipped over that section. There's another myth that I had when I first started practicing, and that was that when an attorney explained to me the assignment, it was going to be this incredibly articulate, well-defined, very clear assignment. That happened occasionally, but that was not the usual way that I would get assignments. Usually, the attorney would be assigning me something because he or she was really busy. I mean, after all, he was taking it from his desk and transferring it to my desk, which means he or she had too much to do. And so, whenever you have more work than you can do, you don't want to spend a ton of time with the handoff. You wanted to move it from your desk to somebody else's desk as quickly as possible. And so when the person would sit down with me, many times they were in a hurry. They hadn't really thought about what I needed to know, or what the uh, uh, details or the scope of the project might be. And so many times when I got to the point that I would ask questions, I would ask a question and the assigning person might say, good question, I hadn't thought about that. Well, let me give you an answer. So you shouldn't assume that this person has a very well-crafted answer to all of these questions. The facts that you get may well be out of order. They may be missing important facts. There may be facts that are included that you don't need at all. Uh, Facts may be missing because the attorney just forgot to share them. It could be that the attorney doesn't know those facts, or it could be that the attorney doesn't realize those facts are important for this analysis. So there can be lots of reasons why facts are missing. The scope of the assignment. The attorney may tell you that he needs an answer on this X question. Well, does he need me to stop by and orally give him the answer? Or would an email be enough? Or does he need a formal legal memorandum? If he needs a formal legal memorandum, is it just going to be used for his eyes only, or is it going to go into a forms file where other people are going to have access? Is it something that he anticipates that he'll be sharing with the client? If so, is the client a sophisticated legal consumer, perhaps an attorney or paralegal, or is this an unsophisticated legal consumer, a layperson, for example? Will the contents of this legal memorandum be repurposed likely into a brief in support of a motion or some other document? All of those questions and the answers to those questions are going to influence how you approach the assignment. And so you need that information. Will the attorney have thought through all those permutations? Sometimes, but many times he or she won't. And you will actually impress the attorney if you're able to anticipate those questions. Oh, wow, this person's on the ball. They're thinking through 4 or 5 steps ahead where we want to be. Then it's also helpful to think about the client's goals. The client may be interested in the quick and dirty answer to the question, or maybe the client sees this as a major issue that could impact it in very significant ways. And so they may want the detailed, very well-researched answer to the question. In the first scenario, it might be something that you return in 2 or 3 hours of work. If it's more like the latter circumstance, you might spend 10 or 20 hours on it. The question is the same. The depth and the thoroughness of your research is what's going to differ. And so knowing what the client is hoping to accomplish and also what the client's budget is huge in deciding how to approach this topic. You'll want to ask questions for clarifications. I mean, you mainly want to do this so that you can get the clarification that you need, but it also communicates to the assigning person, wow, this person's paying attention. They, by repeating what they know and then asking questions, I'm developing a greater confidence level in their competence to handle this issue. So it can actually impress the questioner when you are thorough in those ways. It's also good to make sure that you understand what the deadline is. And while there's a couple things with the deadline. Number one, there may be multiple deadlines in a project. For example, the attorney may want you to stop by the attorney's office and give the quick and dirty answer. And then the attorney may want it formalized in a legal memorandum. So you might have the quick and dirty answer, and then later the formal legal memorandum. And then there might be a third step where you're going to perhaps reduce this to a motion with a brief in support. So you might end up with 3 different documents. And so it's helpful to know kind of what are the deadlines if there's more than one deadline. And then it's also good to know, well, how hard is this deadline? Is this well, the client's expecting to see it about then. I want it a few days before, so let's try for this date. Or is this a court-mandated deadline? And if we're 5 minutes late, it's too bad, so sad for us. The court isn't going to accept it. So there's hard and fast deadlines, and then there's deadlines that are a little bit more flexible. get a budget in terms of time. The budget may be driven by the client or may be driven by what the attorney thinks is a reasonable amount of time. This helps you know whether you're on track, and it also helps you budget your time. Let's say the attorney says, oh, I think this will take you about 4 hours, and I do want a short legal memorandum on this particular topic. For some reason this isn't working. Let's see if I can get this going. Here we go. Well, this isn't going to work today, but so let's say it's 4 hours and you are going to need to have a legal memorandum. Well, you're probably going to want to spend maybe the first 2.5 hours finding the law, reading the law, analyzing the law, and maybe about the last hour and a half having it gel into a written document. Some people spend more time writing, some people spend more time researching, but usually you're going to want to have, either 2 hours researching, 2 hours writing, maybe as much as 3 hours researching and 1 hour writing if it's a more informal written project. A common error that beginning legal researchers do a mistake with is not reserving enough time for the writing. The writing is as important, if not more important, than the quality of the research. And so deciding, you might assign a time to kind of get the lay of the land, figuring out what the issues are, what the scope of the issues are. That might be, again, in a 4-hour period of time, that might be the first 30 minutes. And then you might spend 45 minutes or an hour finding the law, looking at the cases and the statutes and the regulations. And then you might spend, 45 or so minutes actually reading the cases, comparing the holdings in the cases, seeing how things fit together or don't fit together depending upon the circumstances. And then you start writing the project. And how you approach that is, again, kind of for another course, but when you take legal writing, we'll talk about, most people are going to start with having some understanding of what the legal issue is, and so they're going to define the question that they're going to answer. Then they're probably going to go to the discussion section and really answer that question. Once they've done the discussions question, they're going to be able to distill their answer to 2 or 3 sentences, and that's going to become their brief answer. Very likely at this point they're ready to write a conclusion, and then is the time that they will mine their discussion for all the facts that they used and include that in the facts section. So the order that you write the memorandum is going to be very different than the order that the reader reads the memorandum. And so as you're thinking through, you want to think, well, how much time do I need for this? How much time am I going to need for this? How much time am I going to need for this? A good rule of thumb is the thing that is most important, do first, because if you run out of time, at least you've got the most important thing done. So again, generally the discussion's the most important. Then your brief answer is going to be next, and then your conclusion would be a third, and then your facts would be the least important of those items. If you run out of time and all you've written is your facts, kind of a waste of time at that point. My experience with deadlines is that when people give deadlines about, oh, I think it's going to take this long, it invariably takes longer, because when we are thinking about the project, we kind of assume, well, there's not going to be any issues. You're just going to be able to find that the 3 or 4 most important cases, you're going to read them, they're all going to fit together nicely, and everything is going to kind of resolve itself. I mean, that happens sometimes, but more often than not, there's going to be some kinks. I mean, if it were that easy to do, anyone would be able to do this type of work. And so there usually are some surprises. Maybe you find that there really aren't a lot of cases, and so then you have to look more broadly, maybe into other jurisdictions. Or alternatively, you may find there are a ton of cases, and it's hard to sort through and find the ones that are most important. You might find that the cases really don't gel together very well, and so you have a difficult time deciding how to make that story be a coherent story. Another problem that I had a lot of times with research was that I would start with a focused question, and I got this from the attorney, that he or she needs an answer to this question. Then I start looking at the cases and the statutes and other things, and I start having this, what I call issue creep. I think that the issue is this big. If you can see, we'll say the size of this space here. But then I start, when I'm reading the cases, the case that I read might actually see the issue as being over here more. Then I need another case and they see the issue as being over here more. And then there's another case that talks about it being over here. They're all related to my issue, but they've also got other things in it. And before I know it, I've grown my issue to this big. The way that I ultimately kind of made myself stay on point is that I would distill the issue that I thought that I was supposed to answer, ideally into a one sentence or one question statement. And sometimes if I wasn't sure if I was too broad or too narrow, I would actually email it to the assigning attorney saying, am I on the right track here? Is this too broad? Is this too narrow? You know, help me know if I'm off point here. And then I would write that, assuming the attorney said it was a good fit, I would write that on an index card. And every time I looked at a case or a statute, I would compare it to my marching orders. And I would say, does this case help me answer this question? And that kind of protected me a little bit from the kind of nice to know cases. Well, that's nice to know. Well, maybe it's nice to know, but it doesn't help me answer the question. So when you find, let's say again, your issue from the attorney is this, but you start looking into it more fully and you see, gosh, there's this really interesting issue over here that seems relevant to our case. And so you might be tempted to start researching this issue too. I would caution you not to do that for a few reasons. First of all, you don't know about other research that might be going on. There may be another person in the law firm, or if it's a corporate client, maybe someone in-house at the corporation is researching this issue. So we don't want to duplicate research that's happening. Or it could be that the attorney just has already explored this issue in the past and just kind of knows the answer, and so there is no need for research. Or it could be that the client has said, I don't want to pay for that research yet. Maybe they think there's a possibility of settlement, or maybe they think that issue won't ultimately come up. And if also it could be that your understanding of the facts are incomplete, and perhaps that other issue really isn't relevant once you have a complete version of the story. So what I'm saying is, don't inadvertently volunteer for research you haven't been assigned to do. The client may not be willing to pay for it. Your time may need to be written off. And so a good way to approach that is at the end of your legal memorandum or your conversation with the attorney, or however you communicate your results, is to say, by the way, I saw lots of cases on this related issue, and I think this may be relevant to the case. Would you like for me to look into that? And that can that shows you how you're proactive, but it also shows that you aren't kind of taking on work that you haven't been assigned. So that's kind of the right approach to do with this type of circumstance. So these are, and again, these issues are the same whether it's a contract case or a tort case or some other case. These are skills that are smart to develop early in your career. You will find yourself oftentimes in the situation of being assigned these types of projects, and developing good skills to ask questions and to confirm information is something that you will want to do early on in your career. Okay, so we've moved beyond that. We've had that meeting with the attorney and we understand what our question is. Let's talk about how we approach the analysis. I guess the first thing to think about when we're dealing with a contract issue is, are we going to be thinking about the common law, or are we going to be focusing on the UCC? In some times, there won't be a difference in the answer, but sometimes there will be a pretty significant difference in the answer that we're going to get to. So it's important to think through which category of law applies. And so this issue is going to be, is this primarily a sale of goods contract? If so, then the UCC is going to apply if the answer is yes. So, I'm sorry, I should have put a yes here. So yes means the UCC applies, no means the common law applies. Now, if you are researching this issue, the attorney may assume that you know whether the common law controls or the UCC controls. It's just that the attorney doesn't necessarily know what a paralegal would know in this area. And so it's good for you to confirm, oh, you know, Bob, based upon what you said, it sounds like this would be a common law issue. Am I right? Um, Again, that confirmation, one of two things will happen. Number one, he may say, well, yes, you're absolutely right, and then you sound super smart. Or, no, actually, in this particular case, the UCC controls. And so now you've saved yourself a lot of time and your client a lot of expense, and you still sound really smart because you're pointing out where you need extra support. And so be sure to nail that down to know which category of law you ought to explore. Sometimes an issue will be a combination, and we talked about this in one of our previous lectures, where there's a little bit of goods and a little bit of services. Imagine, for example, that I'm buying a wall-to-wall carpet, and I also obviously want it to be installed. I want the mattress pad, and I want it to be attached to the ground. Am I primarily buying the service of having the carpet installed, or am I primarily buying the carpet? Well, it would be a hybrid situation. In that case, my guess would be that the predominant factor would be a sale of goods, and so the UCC would control. But perhaps there are times where that's mainly a service, and so the common law would control. The attorney may know in this particular industry what the case law already provides. So if it's a mixed category, that's especially important to say, hey, should I research whether the UCC or common law typically covers this category, or is this something that you already know and that you can just share that with me? Another issue, this is especially important if you're looking at litigation, is where are you going to file your lawsuit? Let's say that this is a case where you are representing the plaintiff, and the plaintiff is considering to file a lawsuit. So one issue is going to be, which state should I file the lawsuit in? And should I file in federal court or state court? You may recall this from a federal civil litigation or the civil litigation course, or even the intro to a law course, where we talk about how we decide the right court to file in. Here's an example, or this is a picture of the state of Texas with all of our federal districts. We're somewhat unusual in that we've got 4 federal districts. That's the most of any state. There are a few other states that have 4, but none that have more than 4, at least at this time. And you can see here we've got the Northern District. The Northern District actually includes, let's see, I think this might be right here, Dallas County and Tarrant County. Then we have the Western District, which goes all the way to El Paso. Then we have the Southern District, which includes the Valley as well as Houston. And then we have the Eastern District, and that's where we are right here in Collin County. Let me show you a little bit more granular map about that. Here we go. This is the Eastern District. You can see here in Collin County, we actually do have a district court building for the Eastern District. It's on Preston Road, just south of 121. It's a pretty hideous building in my opinion. It looks like a cinder block type building. There's a beautiful federal courthouse in Grayson County in Sherman, if you want to see something more attractive. And you can see that the Eastern District is actually broken down into a variety of sub-districts. Divisions is what they're called. And this is the Sherman division, is the one that we're in. And you can see each one of them has their own, and so it's actually usually named after the city. One is Tyler, one is Texarkana. And typically, other than in this one, there's just the one courthouse typically. So we are in the Sherman division on this map. Collin County is right here. Dallas County, of course, in the Northern District. And this is just a smaller version of that map. So if federal issues arise, which can happen, but more commonly you're going to get into federal court based upon diversity of jurisdiction if you end up in federal court at all. Most contract disputes are probably going to be in state court, but certainly if you're suing somebody from a different state, it could well be such that there's a diversity issue and therefore you can file in federal court. Which state you're going to file in is going to depend upon where you can assert a personal jurisdiction, or which court has personal jurisdiction over the defendant. Again, for personal jurisdiction, we focus on the defendant, not upon the plaintiff. So for the plaintiff, we're thinking about who we want to sue, and we think to ourselves, well, which courts in which states would have sufficient contact with this person that would support their exercise of personal jurisdiction over this person? And when I say person, I don't necessarily mean a human being. We could be talking about a human being, certainly, or we could be talking about a corporation or a partnership or some other legal entity. So an example would be if Bob lives in the state of Oklahoma, then definitely Bob can be sued in Oklahoma. If Bob regularly does business in Louisiana, even though he doesn't live in Louisiana, Bob can also be sued in Louisiana. Let's say we also are thinking about suing Bob's corporation. Bob's corporation is incorporated in the state of Kansas. Its principal place of business is in Oklahoma, so it can be sued in either one of those places. Bob's corporation also does a lot of business in Arkansas. Well, guess what? It can be sued there as well. This is a very detailed analysis, so I'm making it sound like it's very straightforward, but it can be very, very complicated to do this review. But I just wanted to kind of remind you of some of the questions that you'll want to be asking. Another issue to consider, this even is kind of pre-litigation, is, well, which state laws are going to apply? The common law is largely the same from state to state. And certainly the UCC is largely the same from state to state. But there are subtle differences between the version of the UCC we have in Minnesota versus the version of the UCC that they may have in Nevada. And certainly the common law will probably have even more subtle differences between the two. So it's important to figure out which state law is going to apply. Sometimes, ideally in fact, you're going to have it specified in the contract itself. And this provision is called a choice of law provision. Virtually all contracts that are lawyered up that involves a law firm drafting it is going to have a choice of law provision. It just removes any uncertainty about which state law ought to apply. But many times when something is done informally between parties, they may not even have considered the issue of the choice of law. I mean, many times it's very obvious which law is going to apply. If Bob lives in Collin County and he enters into a contract with Larry, who lives in Dallas County, and the transaction is going to occur in Tarrant County, it's pretty obvious that the laws of the state of Texas are going to apply. And so sometimes there doesn't even need to be a provision. You're just going to be able to tell under the circumstances which law applies. So you first of all look to the contract, and if the contract is silent, you look to the facts of the case. Let's consider the issue of venue. So we've decided up here which state or states we can file our lawsuit and whether we're going to file in state or federal court. That's an issue of jurisdiction. Once we've decided where we're going to file, and let's assume we decide Texas and we're going to file in federal court. Now we have to pick a venue. This is a choice between places that already have jurisdiction. So venue is different than jurisdiction. For example, let's pick Potter County up here in West Texas, which is actually the Panhandle. Potter County. If Potter County has jurisdiction over a matter, then that means that El Paso County has jurisdiction. It also means Harris County has jurisdiction. It also means that Collin County has jurisdiction. So if any one county in a state has jurisdiction, every single county in the state has jurisdiction. Another thing to keep in mind is jurisdiction isn't like a dimmer switch on a light. There won't be a place that has a lot of jurisdiction and another place that just has a little bit of jurisdiction. It's more like a light switch. It's either on or it's off. It's either 100% or 0%. Now, certainly there are factual patterns that you look at and go, gosh, that's a close call. I don't know which way the court will rule. You may not, but when the court rules, whichever way the court rules, the court will be saying 100% or 0%. And so that's the standard. So when I say that we're picking a particular place within the state to file, we're not talking about whether that particular county has jurisdiction. We know that because we've already decided this state does have jurisdiction, but we're picking the particular place within that state. So here, we know Texas has jurisdiction. We know the federal courts have jurisdiction. Now we have to decide what's the appropriate place to file the lawsuit. There's a couple of different ways we can approach this, and one of the ways is to look to the contract. Just like the contract can specify the choice of law, it can also specify what's called the choice of forum, where the lawsuit ought to be filed. And this is oftentimes a matter of convenience. Imagine that I'm entering into a contract with Bob. Bob is based in Collin County. Where is he going to want the lawsuit to be filed? In Collin County, right? That's kind of a no-brainer. Maybe that's convenient for me, maybe it's not. If I'm, say, down here in Bexar County, I may think, no, I want Bexar County to be the county that is where the lawsuit's going to be filed. So that could be a point of negotiation between Bob and me. Maybe, you know, Bob gives up a little something in order to get the advantage of any lawsuit being filed in a place close to where he is, or maybe I give up a little something so that I can get convenience in the event it results in a lawsuit. You don't have to specify that in the contract, but you can see how that's a smart matter to resolve in the contractual negotiations. If it's not specified, there's a statute that explains where the lawsuit can be filed. I won't go through the specifics. It's something that is covered in the litigation course. Here's a little map of the various circuit courts in our federal system that we have. You can see that we are in the 11th Circuit, and this is actually not a correct map. I apologize for this. This is not, so disregard this map. Let me find a correct map. And by that, I guess I didn't look before I posted. So let me get a, here, let's see, circuit courts map. Here we go. This is the correct map. So we are in the, that must have been a historical one. So this is the correct map. I'll change the one that I post later on. So you can see we're in the 5th Circuit, and we have Texas, Louisiana, and Mississippi. We used to be part of the 11th Circuit back when, and so, or actually more correctly, the 11th Circuit used to be part of the 5th Circuit. The 11th Circuit was the last circuit added. So once upon a time, the 11th Circuit included, once upon a time, the 5th Circuit included what's now called the 11th Circuit. You may look over here and say, well, why do we have this huge circuit over here? For another issue, or this issue for another day, but there's been a lot of discussion about the possibility of creating a 12th Circuit out here, maybe dividing up the 9th Circuit, because this certainly has a large population. And so that's a possibility for the future. But you need to know that we're in the 5th Circuit, and the 5th Circuit includes Texas, Louisiana, and Mississippi. Okay. So here's a little refresher on federal civil litigation. The court has to have personal jurisdiction and subject matter jurisdiction. And the most important category for personal jurisdiction is whether the court has authority over the defendant in a particular lawsuit. There's a second type of jurisdiction which isn't nearly as important, but this is the court exercising authority over property. For example, a piece of land that might be in the jurisdictional bounds of the court's authority. But most of the time we're going to be looking to personal jurisdiction. The court isn't just required to have personal jurisdiction. That's the first thing that it has to have, but it also has to have subject matter jurisdiction. Courts, depending upon the type of court, it can either have general jurisdiction or subject matter jurisdiction. I'm sorry, general jurisdiction or limited jurisdiction. Limited jurisdiction is when the court addresses cases involving only a certain subject. For example, a family law court, guess what? They only handle divorces and adoptions and things related to families. A probate court, guess what? They only handle decedent estates. Bankruptcy court, guess what? They only handle bankruptcies. Small claims court, guess what? They only handle, small claims. So the names tell you what the scope of that court's authority is. It's not going to handle everything in a particular geographic area. It's just going to handle things related to their particular topic. Another category of courts, though, are the general jurisdictional courts. These are the ones that handle everything that hasn't been carved out into a limited jurisdiction courts. In Texas and in the federal court system, we call these courts district courts, meaning they handle all of the cases in that district unless there's been a special limited jurisdiction court established to address those exceptional cases. And so when you're picking the court to file your lawsuit, and you're going to think, you're going to consider, well, is there a court of limited jurisdiction that handles this particular dispute? Or do I need to go to the court of general jurisdiction? In a contract dispute, you're going to be heading to the court of general jurisdiction. The usual rule, the usual place you're going to go, and this would be true for contract claims especially, is that you're going to file in a state court of general jurisdiction. So in our case, it would be a Texas district court. If you want to file your lawsuit in federal court, the plaintiff needs to have some basis for that court to exercise jurisdiction. One way can be if you're suing about a U.S. constitutional claim, or a federal statute, or a U.S. treaty. You can also sue when you're suing the federal government. That would be another way. So I'm lumping all of these together in the kind of the federal question jurisdiction category. These really aren't a very likely path for contract law, with the exception of the U.S. government. More likely, though, if you're going to get into federal court, you're going to get into federal court based upon diversity of jurisdiction. And this is when you have parties from two different states, or from the United States and another country, and, so this is an and situation, and the amount of dispute is more than $75,000. The $75,000 hurdle, by the way, or threshold, is statutory, so that can go up over time. When I first started practicing, it was $50,000, and it's been $75,000 for a very long time. It's likely, or common sense would say it's likely to go up, although there's a lot of politics involved in that choice, so who knows when it'll actually happen. Okay, so sometimes when you get a lawsuit, or when a plaintiff is filing a lawsuit, the plaintiff will have a combination of state law claims and federal law claims. And so the question is, well, do I need to file two lawsuits? Do I need to file in state court on some of these matters? And do I need to file a separate lawsuit in federal court? Sometimes the answer is yes, and sometimes the answer is no. But probably more often than not, the answer is no. Usually you can put all of those things into the same lawsuit and go ahead and file it in federal court, assuming that they're all about the same transactions. Questions the court's going to ask are the same witnesses going to have to appear? Are they going to testify about the same facts? So imagine for a second that this is about a breach of contract. Let's say it's an employment contract case, and the former employee is suing because he feels that he was dismissed unlawfully based upon the terms of the employment contract. And so maybe the standard was he could only be fired for due cause, and he feels like due cause wasn't present. And so he's saying that there's a breach of contract in this case. In addition, he might say, and I also feel that I was discriminated against because of my race. I'm African American. So if the same types of facts are going to be relevant to that transaction, maybe why he was fired, what were the facts leading up to being fired, the court would probably say, yeah, I mean, it makes sense just to hear the story once, right? I mean, why inconvenience two juries to hear the story? But let's say instead of it being a breach of contract case, maybe it's about some stock options that did not vest as they were supposed to according to the formula that he got in his stock options. But that wasn't part of his contract. And so you could really separate those two and talk about his employment contract and what happened with that completely separately from his stock options. In that situation, if one of those topics there is federal jurisdiction, the other one there's just state jurisdiction, the court may well say, no, we can sever those. We can treat those as separate issues. So that's what we're focusing on when we're talking about pendent jurisdiction. Other terms for pendent jurisdiction, by the way, are ancillary and supplemental jurisdiction. I have no idea where we have three words for that in English, but we do. And this is focusing upon that idea of judicial economy. It doesn't make sense to have two different judges hearing the same case. That's inefficient. Let's consider the idea of concurrent and exclusive jurisdiction. I said before, going back to this list, oops, here we go. Here we go. That these were the bases that you used to get into federal court, and including this one. Well, if you are saying about the U.S. Constitution, you can file in federal court or you can file in state court. So this is an area of, let me just see if I can make this work. This is a little bit frustrating. Discard. Now I'm going to see if I can, we'll see if it's going to work this time. Maybe if I try a different color. Nope. Okay, so for suing about the U.S. government, that's concurrent jurisdiction. So imagine you're seeing a C here. Maybe if I try a highlighter. Nope, not going to work there either. I'll do a laser pointer. So imagine a C here. You can file in federal court or state court. If it's a U.S. treaty, though, you have to file in federal court. So we call that an exclusive jurisdiction category. If you're suing the U.S. government, you have to file in federal court. So that's an exclusive jurisdiction situation. So concurrent means you can file in state or federal court if you're the plaintiff. Exclusive means you have to go to either one or the other. Now, the state court might have exclusive jurisdiction, or the federal court might have exclusive jurisdiction, depending upon the circumstances. Okay, so in sum, the questions that we're going to think about as we try to decide when we're representing the plaintiff where we ought to file our lawsuit is, does state law apply or does federal law apply? Is concurrent jurisdiction an issue? And do the contractual terms determine where jurisdiction and venue appropriately exist? So those are some things to consider as we're considering the issue of jurisdiction. Okay, so now we've decided what body of law we need to look at as we now analyze this problem. And now we're going to think about, well, what is the problem? What kind of bucket, what kind of category of problems are we confronting in this case? Is this about, did a contract actually get formed? Was there an issue about whether there really was an offer and acceptance, or maybe there's an issue about whether the contract was legal, or maybe there's an issue about whether there was adequate consideration, or maybe there was an issue about legal capacity of one or both of the parties. So we're all about, did we actually form a contract? Is that the type of issue? Another issue might be, is the contract enforceable? And you can see there's some overlap here, because I'll say the contract is unlawful in some sense. Well, then it probably isn't going to be enforceable. That has to do, it's also related to the formation. Even if one party, say, was a minor at the time, that relates to formation, but it also relates to enforceability. So these two are oftentimes closely related to one another. But the issue may instead be performance, and this is perhaps the more common area, or performance and breach. These are kind of partnered up together. And this is the issue of, well, Bob did something. He thinks he satisfied his obligations in the contract, but Larry's saying, I don't think so. I don't think Bob did what he needed to do. And so now you're comparing the actions or inactions against what the language of the contract is, and you're trying to decide, do they fit together? Are they sufficiently close to each other that there is actual performance, or are they sufficiently distinct from one another that there is in fact a breach? I would say most contracts are in this, most contractual disputes are in this area. If you have decided that yes, maybe there is an issue about any of these issues, then you have to consider, well, what remedies, if I'm successful, if I'm able to persuade the jury that my explanation of the facts are accurate, what as a plaintiff am I entitled to get? It may be that I'm going to win, but what I win is not worth very much or isn't that helpful to me, and so it may not be worth my time to pursue this case any further. Now, obviously, as we even saw kind of from my examples, is how you present the problem may ultimately affect your analysis. So for example, a problem could be, well, did you actually form a contract? Or you can see that same issue as, well, if you didn't form a contract, it's not going to be enforceable. So these are somewhat related issues. Or maybe the issue is, Well, if the contract isn't enforceable, then there's no duty to perform, right? And if you have no duty to perform, then you can't breach it. So in some sense, all these terms are very much interconnected. And so you might have an issue that you look at as a formation issue, but maybe the defendant sees it mainly as a performance issue. And it depends upon what facts you emphasize, uh, what your perspective is. And so it's helpful to step back when you look at these problems and say, okay, this is how my client sees it. This is the vision of the case that's helpful for my client. But how is the other side likely to see these same facts? What facts are they going to see as more important? Are they going to see it as through a different paradigm, through a different angle than I am? And then, of course, finally, what would a disinterested third party see in this case? Probably it's going to be somewhere between the plaintiff and the defendant. And so it's useful to have a variety of perspectives as you analyze these fact patterns. So when you're considering the remedies, some things to think about are, do common law remedies apply? Of course, we already discussed how at the very beginning we decided whether common law controls or the UCC controls. So obviously that would be related to this analysis. But of course, whether it's a common law contract or a UCC contract, the parties may well have included their own, for example, liquidated damages provisions, or perhaps they've included an exculpatory clause in the contract, which then varies what the traditional remedies might be available under those fact patterns. And then the issue might be, well, are those contractual provisions going to control, or perhaps they're unenforceable, perhaps they're unconscionable, or the courts have traditionally not applied those standards in this particular situation. There may be issues about whether the plaintiff wants to seek legal remedies or equitable remedies. And again, this is analysis that you've covered in other classes. This has to do with, whether you're going to get money, which is the legal remedy, or whether you're going to get a court order, some requirement that somebody do something. That's an equitable remedy. And so that can be something to consider. Typically, the plaintiff wants a legal remedy, and that's what the court's going to be much more interested in providing. But under unusual circumstances, courts can be persuaded sometimes to order equitable remedies as well. Examples of equitable remedies would be an injunction or specific performance, or, for example, replevin. We already said the outcome may differ than what it would be under common law, so you want to and analyze the case in a similar way that we did when we were talking about common law. Look at the elements that we need in every contract, but recognize that there are some differences. So you want to be aware at the beginning of your investigation or your analysis that's UCC versus common law. You will end up maybe not being the most productive with your time if you don't make that distinction early on. You may find the answer to the common law question, but if your correct answer is a UCC question, then you've gone down some blind alleys that weren't necessarily helpful to the analysis. Okay, so let's do a little bit of refresher about how we approach legal research. And this is just going to be a little bit of a reminder. If you haven't taken legal research yet, some of the things I'm going to be saying may be not that familiar to you, although you may have heard about them in the Introduction to Law course. But if you've taken legal research, hopefully this is a little bit more familiar to you. So we're not going to do a deep dive here. Certainly this is not a legal research course. But typically when you start a legal research project, especially if it's an area of the law that you're not that familiar with, you're likely to start with secondary sources. Secondary sources are helpful. Let me move ahead here for a second. Secondary sources is a legal resource that interprets primary sources or presents an opinion. I like to think of there being three functions for a secondary source of law. One is it can help you understand a primary source. The classic example of this is, my guess is when you fill your federal income tax return, you don't go to the IRS code and read the actual statute. I don't think even tax attorneys do that when they're doing their own tax returns. That would be really, really difficult. No, what we do is we look at the instructions that the IRS gives us. Now that's really not a secondary source because it's actually from the government. But what we might even do is we might go to H&R Block, or we might use Quicken Books to help us. Well, guess what? H&R Block is not a branch of the IRS, and neither is Quicken Books. Those are for-profit organizations whose mission is to simplify make it very easy, or at least easier, for a layperson to interpret and apply these very technical rules to their own economic income situation. And so they are interpreting, assisting, explaining, dumbing it down, you could say, a little bit. That's one big function of a secondary source. Another is to help you find primary sources. Sometimes it's tricky to find cases. After all, the reporter systems are not arranged thematically. The cases are printed chronologically. And so in the reporters, you'll have a murder case next to a breach of contract case, next to a divorce case, next to a dog bite case or whatever. And so to find cases that are relevant to your particular issue almost always requires that you use some secondary sources. And then the third source is when you confirm, the third function of secondary sources are to confirm the accuracy of your legal resources you're using. Think about that case that you found that seems perfectly on point. You're thinking, this is exactly what I need. Well, you're not done when you read it and analyze it, because guess what? Let's say that opinion was published in 1990. Well, the day that it appeared in the reporter was probably a few weeks after it was published. But it could be 6 months after that, the Texas Supreme Court overruled that decision. Guess what? Nobody goes back to that reporter and razor blades out the case after it's been overturned. Doesn't happen. And so just because it's in the book doesn't mean it's good law. There could have been a higher court that reversed it. There could be a statute that came down that either nullified it or limited that particular decision to its facts. And so for that reason, you always have to make sure that the law is good law. And we use what's called a citator for that purpose. Most people, though, don't call them citators. They call it Shepard's. Shepard's is the brand name that people use for this. LexisNexis has the Shepard's tool, owns the Shepard's product. Westlaw has something called KeyCite, but it's exactly the same as Shepard's. And in fact, KeyCite has become increasingly popular, and so there are people who might even use the term KeyCite instead of Shepard's, but most people will say Shepard's. It verifies with the primary source it relies upon or analyzes. And it also verifies the accuracy of primary sources. So those are the three main purposes of secondary sources. There is a fourth, and that is secondary sources will sometimes present an opinion. Most of the time when you're doing your legal research, you're not interested in the opinion of somebody. You want to know the law. The only opinion you care about is a judge's opinion, not what a law professor somewhere says. So usually the opinion focus is not what you are going to be looking for in a secondary source. So if this is an area of the law that you don't have, actually, before we go here, let me just show you one example of a secondary source. Actually, I'm going to show you a couple of examples of secondary sources. Here we go. Here's a list of some secondary sources. We have Farnsworth on contracts. This is a Horn book, very, very well regarded Horn book. Calamari and Perillo, this is also a very reputable Horn book. Lots of legal professionals use this one. And Corbin on contracts, this is the one I used. It's C-O-R-B-I-N. This is the one that I want you to remember. Corbin on contracts. Williston on contracts is another big one. So, but for our purposes, just think about, here we go, this one. I'm also going to show you the restatement of the law of contracts here. I have this available. I'm going to go over here. Let's see if I can get rid of that annotation. Here we go. Let's clear all drawings. Okay. This is the definition of contracts that we have in the restatement. The restatement is a secondary resource. What happened is that a lot of legal scholars got together and they said, look, wouldn't it be nice if we had kind of a one-stop shopping for all the contract law, just one central place you can go to find the ins and outs of contract law. It's a lot bigger than a hornbook is, and it's very, very detailed, but it reads like a statute, even though it, of course, isn't a statute. Okay, so this is the first section of the restatement of contracts, and so it's section 1, and it defines a contract. When I read this to you, you're going to think, wow, I know I've heard this before. Well, you're right, you have. A contract is a promise or a set of promises for the breach of which the law gives a remedy, or the performance of which the law in some way recognizes a duty. When you hear this, you're probably like, isn't that the definition we've had in this course? Pretty darn close to the definition we have. This is the one that you see all over the place. In my opinion, it's not very satisfying, in part because the concept of contract is just so basic to the law. It's really hard to define something that basic. It's like defining the word "the" or defining the word "red." How do you define red? It's just such a basic concept. It's hard to do that. For our purposes, remember this last word here, duty. Okay, so I'm going to flip back. Let me clear this now. I'm going to flip back to our, oops, here we go. Get rid of that. I'm going to go back to our PowerPoint. So we've talked about our secondary sources. Again, the Corbin is the one that you need to know about for our purposes. So we've gone to the secondary sources if we needed to, and we found the primary sources that we need. And so now we're going to talk about the primary sources here. So what is a primary source? I like to think about the primary source as being the law. Still not going to work for me. It's somebody in the government who is acting in his or her official capacity, makes an announcement. It may be a smart idea. It may be a dumb idea. It doesn't really matter. It's going to be the law because the person who has that authority says it. So primary sources are legal resources that include things like constitutions, cases, statutes, sorry about this typo here, this should be statutes, not states, administrative rules and regulations, and court rules. So that's of course, when we're talking about secondary sources, we're talking about things that are not produced by the government. So primary sources fit in, secondary sources are by definition going to be persuasive sources of law. Primary sources can either be mandatory or persuasive. To me, this is confusing, so I always have to stop myself here to get this straight. So if you struggle with this, you're in good company, or at least you're in company with me. I don't know if that's good or not, but in any event, a mandatory source of law is one that is binding. You have the court in which you are appearing has to follow it, even if the judge completely disagrees with that. For example, let's say that the legislature in Austin passes a law, and you're appearing in front of a judge who thinks the law was really stupid, really, really stupid. This judge campaigned, wrote letters to his or her senator, and said, please don't pass this law. The judge was very vehement in his mind that this was a very bad idea. So now you're in front of him, and your argument is, well, you just shouldn't apply this law because it's a dumb law. The judge may well say, you're right, it is a dumb law, but I got to apply it. I don't have a choice. My job is to apply the law. I'm not a member of the state senate. That's not my role here. If I were a member of the state senate, I would have voted against this. I would work tirelessly now to repeal this law. But right now, my job is to apply the law. And unless I think there's something unconstitutional about this law, my hands are tied. I am bound to follow the law according to my oath, and so I must follow it whether I agree with it or not. Persuasive sources, which would include secondary sources, are legal authorities that the current court does not have to follow. The court follows that resource to the extent that the court is persuaded that that's a good resource. So primary source of laws are going to be the state legislature and courts within its jurisdiction that are higher than it is. So for example, a Collin County judge handling a civil case is going to have to follow the Texas Supreme Court, and he's going to have to follow the Texas legislature. An example of a persuasive source could be the Oklahoma Supreme Court decision. Obviously, we're not in the state of Oklahoma, and so the judge wouldn't have to follow that Oklahoma Supreme Court decision. But let's say there's no controlling authority in Texas, and the judge felt that the Oklahoma Supreme Court issued a very well-reasoned decision. He or she agrees with that decision. He or she is persuaded by its wisdom. That's when he's going to apply the persuasive authority. So this authority only controls to the extent that it persuades. So if you don't have any mandatory sources of authority that you can find in your jurisdiction, that's when you look outside with the understanding that you have to do a little bit more work, because you don't just present it and say, here you go, Your Honor, this is what you got to do. We don't care if you like it or not. You've got to say, this is what we want you to do, and these are the policy reasons and the analysis that hopefully you will reach the same decision or the same analysis that this court did. Once you're done with it, let's assume you've written up a legal memorandum, you've done all of your research, you've done all of your analysis, you have all the pieces put together. Virtually the last step you're going to do is finalizing your document. And let's look at some of the things you're going to do when you finalize your document. Obviously, you're going to check grammar and spelling. You're going to want to avoid passive voice when you can. You're going to want to review your sentence structure. Are you keeping sentence lengths relatively short? Are you keeping paragraph lengths relatively short? Are you varying your sentence structure? All those things. Have you edited and revised so things flow logically? Have you checked for typos? Have you read it for clarity? Have you asked somebody else to read it to see if there's a logic flaw or something that's missing from the facts that you can't see because you spend so much time with this particular case? Probably one of the last things you're going to do is you're going to blue book it and you're going to green book it. We blue book first, and then we green book. The blue book is a document that is published by I think four law schools in the Northeast, and this is a book that is used pretty much throughout the United States in virtually every court where people appear. The green book is a Texas-specific book, so this would apply in a Texas state court and Texas federal court. When you are practicing outside of the state of Texas, you don't have to do the green book stuff. It wouldn't be wrong to do so, but it wouldn't be required. You would still do the blue book, though. Let me... I don't have anything about the blue book. Just for this course, we don't go into the details of the blue book. You'll learn more about the blue booking and green booking when you take legal research, when you take Introduction to Legal Conventions, and when you take legal writing. So I hope that this presentation has been helpful for you. If you have any questions about the material, please don't hesitate to reach out to me. My email is cgroover@collin.edu, or better yet, stop by. I'll be glad to talk with you in more detail about these topics. Thanks so much for your attention, and I hope that you have a wonderful day. Take care.